Hi folks, it's June 20th. Parliament has just recessed for the session. We'll be back in September. However, there's certain things that are also happening today, such as the royal assent being received for Bill C-59. Now, Bill C-59 was the Fall Economic Statement Implementation Act, and part of that wasn't part of any finance part, it's the changes to the Competition Act. So I want to let you know that I may be breaking the law somewhat by what I'm saying here today. We'll have to find out. But no matter what, it's going to lead to a whole bunch more fractiousness here that will lead to more cases coming before the Supreme Court of Canada and a lot more expenses being incurred by entities across Canada. Let's get into it. Part of what matters here, recall back in 2019 when the infamous Bill C-69, the Impact Assessment Act, No More Pipelines Act as we call it, was passed through Parliament. What that meant was that it opened up the whole consultative process for any type of infrastructure build across Canada, which includes energy and resource developments, had any party allowed to come in and be funded for their participation in those hearings. That's something that's going to be revisited here significantly in this new bill. Folks, first of all, liquefied natural gas, we're developing that in Canada. It's going to be good for the world. We all know that liquefied natural gas has half the carbon footprint of the coal it's replacing in Canada and around the world. Recognizing Canada how much we've abated our coal consumption and moved towards natural gas consumption and how much of a difference that has made in Canada's carbon footprint. We'd like to do the same for the world. Part of the impetus here, of course, is organizations that are very fond of this government have asked for this to be put in the legislation, and they call it greenwashing. It effectively puts the onus on the companies to prove that they, in fact, are going to be benefiting the environment. Let's go into it further. This reminds me of a private member's bill that was in front of Parliament, Bill C-372, introduced by Charlie Angus, a new Democratic MP that isn't running again, and it was never going to be heard in this Parliament. It was way down the order, and that's a different discussion. But he put it up there as a kind of a flag to say, look how virtuous I am in this respect. What it was really going to do was muzzle people like the LNG industry, organizations that were building more environmentally friendly projects for the benefit of the world and the benefit of Canadians. I didn't comment on it for a good reason, because it was a stunt. Unfortunately, that stunt is the same thing that's embodied in these changes to the Competition Act. We've got to pay close attention to this. Part of the issues around this, of course, are opening up the Competition Act so that, in fact, it's a reverse onus act. You've got to prove what you're saying is in fact true, even though it's scientifically already there. And anybody, not just the Commissioner of Competition, can bring this to the courts. Anybody can now bring this to the courts. Like I said earlier, it's a repetition of what happened in the Impact Assessment Act, where you have more and more bodies, many of which are funded by the federal government, putting legal impediments in the way of project development. Let's recognize it's going to cost millions of dollars of civil fees, legal fees that are going to have to be incurred by the corporations that are advancing this in order to make their projects work. This is another impediment, another bureaucratic impediment in the way of getting projects built in Canada. Who's going to benefit from this? Well, I assure you, we've done a bunch of research on how many of these organizations that get in the way of all of the projects across Canada are funded by the government to the tune of hundreds of millions of taxpayer dollars. Another thing that you want to take a good look at here is ill-defined concept like internationally recognized methodology. This is nowhere defined in this act, but suddenly an internationally defined methodology is going to be part of this legislation. We need to understand what that is, because right now they're just guessing. We need more energy produced in the world. We don't need more impediments to energy being produced. We need more energy. If there's one thing I want to make clear to everybody, it's that notion around what we need to do is decarbonize is a solid notion. Decarbonize our energy development. That means getting better energy more efficiently. But unfortunately, the voices in Ottawa, and I tell people this all the time, we are the only party, the Conservative Party is the only party that is about responsible resource development. The other parties would like to shut oil and gas development down as quickly as possible, even when it reduces emissions around the world, like our liquefied natural gas plants are aiming to do. We need to get behind that. Everybody understand what this means, because this is another impediment to the development of our country, to the development of carbon neutral solutions around the world, and actually making things better, not just for Canadians, but for people around the world. Thanks for tuning in.